Hey guys, I took a little sneak peek to try to show you what happened at the appellate's court yesterday. Um those who are interested in watching, we're gonna go ahead and play it for you guys. Come on in, tap on in, tap on in. I'm not gonna keep this live on. I'm just gonna play it for you guys so you guys can see what happened. Um where are you guys at? Where are you at? Where are you at? I know. I'm about to play it for you guys. What happened on the with the appellate's court yesterday? Hey, Jenna. I'm gonna show you what happened with the Harvey Weinstein's appellate court yesterday. So I'm gonna play it for you guys. You know me, I got like to bring information to you guys. Hold on. All right, this is the hearing. All right.
Four and four for the four
Hold on.
case will be called
Hold on. Trying to back it up a little
People
bit.
versus
Okay, here come these ladies, y'all. Look at them. 5 ladies. 1, 2, 3, 4, 5. That's the appellate court in New York. That was the hearing yesterday with Harvey Weinstein
Good
situation.
afternoon and welcome to the Appellate Division First Department. I will give you our usual spiel. We have read your cases. Your briefs are familiar with the issues raised therein. We have 7 hours of requested argument time. Clearly, we cannot grant 7 hours worth. So please ask for what you need, not what you want, or I will be forced to do it for you. Okay. People versus Robert Goodwin. Six and 2 and 7.
Okay, guys, I'm just gonna let y'all listen because I have a meeting to go to. Remember, my meeting's at 7:30, 11:30. So I'm gonna just play this for you guys to listen to. I'll be back.
Caino versus City of New York. Okay, 6 and 2 and 6. Matter of Kenneth S. versus Janice C. is submitted. Gordon Ostajic versus Life Medical Technologies. Okay, 5 and 1 and 5. Powell versus Building 874 Flatbush. Three and 1 and 2. People v. Jean Herrera. 6 and 2 and 6. In-house group versus Total World. Is there a cross appeal? 3 and 1 and 3. Wu versus Sabrina Balsky Interior. 3 minutes. Respondent is requested no time. People versus Randell Smickle. 5 and 2 and 5. People versus Raymond Reed. 4 and 1 and 4. TG Children. Okay, 3 and 1 and 3. Vargas versus Virus Construction. 5 and 2, 5 and 1 and 3. Jonathan Perez is submitted. Kutcher versus Sohagia. Sorry if I mangled that respondent's name. Thank you so much. Submitted. Baychester Retail versus City of New York. Five and 1 and 5. People versus Harvey Weinstein, and this case will be called last on the calendar so that we can get rid of all of our inventory, okay? And you're, okay? Okay. Request granted, 10 and 2 and 10. Jerome Walker, People v. Jerome Walker, submitted. FX Funding versus Fox RX. 3 and 1 and 3. City of New York versus Horlick. I understand we received a phone call from someone for the Horlick case. For which part? Are you here for both Horlick and 1600? The city. Okay. I'm saying the appellants called and said they were having trouble getting here. So I know that they want to argue. How much time are you can respond to both appellants together? Okay, how much time do you think you need? Okay, so I'm going to give 4 and 2 to each of the appellants and 4 and 4 for the city to respond to them, okay? All right. And Eisner versus City of New York is submitted. First case on the calendar, People versus Robert Goodwin.
Good afternoon, Your Honor. Megan Tallmer for Defendant Appellant Robert Goodwin. Appellant's chief contention on this appeal is that he was denied his constitutional right to represent himself at trial. For purposes of this argument, I will assume Your Honor's familiarity with the record of appellant's appearances in court from February 1 to April 25, 2018. In 1974, in People v. McIntyre, and 1975 in Ferretta v. California, the Court of Appeals and the Supreme Court respectively recognize that both the federal and state constitution guarantee a defendant the right to represent himself at trial. Although McIntyre has been the law for almost 50 years, as recently as last year in People v. Trammell, this court found it necessary to remind both calendar part judges and trial judges that under McIntyre, when a defendant makes a timely, unequivocal application to represent himself at trial, the court's only function at that point is to conduct an inquiry into whether defendant's waiver of his right to counsel is both knowing and voluntary. Trammell cautioned the lower courts that it's not enough to give lip service to a defendant's constitutional rights while essentially negating them by failing to have a prompt waiver inquiry, discouraging a defendant from exercising his constitutional rights, refusing to relieve assigned counsel over defendant's protests, or by provoking a defendant into misbehaving over the court's failure to comply with its own legal obligations.
Counsel, can you tell me why, because I'm assuming that you believe that Judge Scherzer's questioning was insufficient. Explain to the court why the judge's inquiry regarding his age, his education, his work history, and his criminal history falls short of the standard you are describing.
Well, it's not necessarily that it fell short, Your Honor. It's that it was suspended when, I mean, it was completely fine up to the point when defendant told Justice Scherzer that he was under the influence of pain medication for surgery that affected his thinking. And she appropriately at that point said, then you can't make such an important decision today. We'll have to put this off. So her inquiry was fine. It just wasn't ever completed, and there never was a final determination by Justice Scherzer or by any other judge on the appellant's application to represent himself. That was the problem.
So the medication that the defendant spoke of was for a surgery, not
I
a
believe he
mental?
said he was still taking pain medication for recent surgery. And at that point, she quite appropriately said, well, look, we'll have to stop for today. Contrary to the people's representation, she didn't deny the appellant's application. She twice said, I am denying it for today, meaning I can't make a decision today. You're not even in your right mind at this point. So her inquiry was completely proper. It's just that it was never completed. When appellant reminded her on the next date that they were in the middle of the waiver inquiry, she cuts him off very abruptly, sends the case out for hearing at trial, but assures him that he can take up all the issues as to how he wants to proceed with the trial judge. But then when he tries to raise it again with Justice Edwards the next day, she says, apparently relying upon an incorrect notation on those index cards informally kept by preceding judges, well, look, your application was already denied. She says, that ship has sailed. So the people's claim that appellant somehow abandoned his request to proceed pro se, well, once a trial judge tells you your ship has sailed, any further protest on his part would have been futile and could have resulted in his expulsion from the courtroom, as Justice Bybin had threatened. So, Your Honor, in this case, there's no dispute that the appellant made repetitive, insistent indications of his constitutional rights. There's no dispute that on 2 separate occasions, the Calendar Park judge did not engage in the waiver inquiry. There's no dispute that when it finally was commenced on April 17th, it was never completed and that there was never a final determination. Given these indisputable facts, a straightforward application of McIntyre and Trammell require reversal. I'm going to save for rebuttal my answer to the people's attempts to justify the failure to have a waiver inquiry because my time is almost up. Thank you.
Thank you.
May it please the court. Good afternoon. I'm Karen Schlossberg for the people. On those facts, it does seem perplexing. If those were the facts of the case, it would be surprising, but those are not the facts of the case. The facts of the case are that the defendant appeared first before Justice Bybin and had been difficult and argumentative and disruptive for many months
Well,
before.
Trammell says that is not an excuse to not engage in the proper inquiry that is required when this request is made.
Well, I wouldn't want to just argue with you particularly about what Trammell says, but my understanding is that that the issue in that case in particular was you can't retroactively, you can't induce disruptive conduct by denying the motion to proceed pro se, which is what I think this court felt happened in that
Well,
case.
in Trammell, he, like this defendant, repeatedly asked to go pro se.
Right.
And the courts did not engage in the inquiry and instead kept on posing every possible obstacle other than what the law requires, which is a inquiry into the fitness of the defendant to proceed pro se. So explain to me how that was satisfied here.
Well, okay, that's not actually what happened in this case. I mean, first of all, I think we have to be clear. The law is, if a defendant is disruptive, that is a grounds to deny the
Right, counsel,
request.
I'm going to ask you again because I asked you a direct question and I expect you to answer it.
I'm sorry.
So the question is, explain to me how there was a satisfactory inquiry here that one can say that his constitutional rights were not violated. Because let me just say, speaking only for myself, I saw nothing in this record of his behavior and his insistence that he had a constitutional right to represent himself. He repeatedly said that.
He did.
He told the court that the court had no right to force a lawyer on him that he didn't want. So he could not have been more clear. And as was said in Trammell, it is understandable that a defendant who continues to assert his constitutional rights and those rights are being ignored would be frustrated with the court. So
I agree that that's understandable. What I disagree with is that that's what happened here. And I would just urge the members of the bench to look back at the record before Justice
Counsel,
Biden.
where in the record, because this does seem a case very much like Tremor, where the disruptive behavior was in response to the court not addressing his inquiry, and you're saying it's otherwise, where in the record can you show him being disruptive, except in response to being denied his right to counsel? And where in the record can you point to the court ever during an inquiry in response to his repeated requests again and again and again, not just a few times to represent himself? When did he ever get a response to that?
That's what I'm trying to get to.
That's what I'm asking.
Before Justice Biden, she was not denying his request. She was very clearly not denying it. She kept saying, I'm not ruling on this right now. I'm sending you to another judge. And he was so disruptive and obstreperous and
Why
argumentative.
wasn't she ruling on it? Isn't that her obligation
Because she
to
wasn't,
make a ruling on it?
no, because she was just sending the case to another judge. She said, I'm going to let that judge decide whether you should try it.
And that's what every judge did. Every judge said, I'm not ruling on it, I'm not ruling on it,
No,
I'm not
actually-
ruling on it. He never got his inquiry.
Actually, what did happen is this. She said, I don't think I should be the one to rule on this because I'm not going to be handling your case. But he refused to let it go, and he kept arguing. And he had been disruptive, by the way, just for the record is clear, he had been disruptive long before he ever brought this issue up.
But
And she had
wasn't his
noted it.
Okay, yeah, I just want to go all the way to Weinstein. Sorry, I had a meeting to go to. Let me go to Weinstein's part. Hold on. Hold on. Okay, I don't want to miss his part. Okay, we're going to start at 16. Hold on. Okay, we're going to start from up. We're going to start from here.
versus Harvey Weinstein.
Good afternoon to the court. I'm Barry Kamens on behalf of Harvey Weinstein. I want to begin with the juror issue, Your Honor, but before I just wanted to state very briefly that the trial court's rulings on both the Molyneux and Sandoval issues were unprecedented and not the straightforward rulings that should have been made as in any other criminal case. And these rulings cumulatively prevented Mr. Weinstein from taking the stand in his own defense and from getting a fair trial. Now, with respect to the juror issue, on January 22nd...
Could you just go back to what you started to say? You said,
I'm sorry, I can't hear.
can you just go back? You started to say something about the nature of the rulings or the manner in which the rulings on Molyneux and Sandoval were made. What did you mean by that?
Well, Your Honor, I'm going to get to the Molyneux after I finish with the juror issue. If you
If you don't mind, taking my cue as to what I'd like to hear about.
want me to address the Molyneux first, Your
No,
Honor?
you said in your introductory statement that the Molyneux and Sandoval rulings were made in a manner that was unusual. Didn't
They were
you say that?
unusual, Your Honor, first because the Sandoval ruling is unprecedented in that it allowed 28 prior acts to come to be used against the defendant should he have testified. That prevented him from taking
So
the
you're
stand.
talking about the content of the ruling
Yes,
then?
yes.
Not about anything about the manner in which it was rendered. Is that correct?
Yes.
Okay. Now go ahead the way you want to. Thank you.
Okay, thank you, Your Honor. With respect to the juror issue, on January 22nd, when the juror number 11, said that there are predatory men in the book, the trial judge knew or should have known that the juror had misled the court 5 days earlier when she said they were not predatory men in the book. And this was reversible error because the judge at that point did not discharge the juror, and that was not subject.
Mr. Kamens, this whole case is about intent. Am I
Yes.
correct? About whether the acts were consensual or forced, what was the defendant's intent? And I mean, the defense took a position publicly that, in the public, he didn't testify, but there were certain statements made publicly about, whether that everything was consensual. There was the issue of the intent was hotly contested here. Doesn't that affect the court's ability to make the Molyneux and Sandoval rulings that it made?
Well, Your Honor, if I, if you
I'm
want me to
sorry I
jump,
interrupted you on the juror again, but that's okay.
I'll get to, believe me, I'll get to the Molyneux, if I can just finish the juror issue that I started. And I understand your point, Your Honor. When this judge refused to discharge this juror, it was harmless. It was a reversible error, not subject to harmless error. He only asked for unequivocal assurance at that point that she could be fair, but it was too late for that. We know from the Southall case, we know from the McGregor case, that it's too late. At that point, the juror had demonstrated actual bias, and that bias could not be cured by unequivocal assurances that she could be fair. And there were many reasons why he should have discharged.
Counsel, isn't your argument that she was biased against your client undermined by the fact that she voted to acquit on, I think it was 5 of the 7 counts?
Well, she was biased for what reason, Your Honor?
I'm sorry?
I'm sorry, I didn't hear the question.
You're arguing essentially that she was biased against your client and was not fair, but
She
isn't
lied,
that...
she lied to the court.
I understand. I'm asking you a question. Isn't that argument undermined by the fact that she voted to acquit on 5 of the 7 counts?
Well, Your Honor, the fact that she acquitted the defendant on some of the counts is not dispositive of the issue that she should have been discharged immediately. It's irrelevant that she acquitted, Your Honor. She should not have, if the Molyneux issue and the Sandoval issue had been decided differently, the defendant may have been acquitted of all the charges. So I don't think it's undermined in any way. But getting back to the juror, Your Honor, she misled the court, she obfuscated, which is a nice word of saying that she lied to the court, and she had an economic interest. Her professional interests were tied to the outcome of this case. She wanted to get on this jury. She had an economic reason for wanting to get on the case. She had an economic reason for wanting to convict the defendant. And the Court of Appeals has repeatedly said that court should lean towards disqualifying a juror of dubious candor. No one had more dubious candor than juror number 11. It would have been the easiest thing for the court at that time to discharge the juror. Under CPL 270-15 subdivision 4, the challenge for cause was proper at the time that it was made of this juror who had already been sworn. The defense raised the ground that was not known at that time, and the defense, and as you know, no witness had testified. After the court proceedings on January 17th, the defense first learned new information about juror number 11, which they brought to the court's attention in a letter on January 20th.
Can I just stop you for a minute? Because I think we have to look at this as a continuum of time. So in looking at what the judge did prior to January 17th, when the defense learned about the juror, don't we look at what the judge knew or could have gleaned from the record at that time? This is going to be a compound question. And wasn't it appropriate? And isn't a judge allowed to say, well, I believe the witness, she tells me, even though she's writing this book, that she can be fair and impartial. Isn't that okay?
On January 17th, he was allowed to believe her, but on January 22nd, when she said something which showed the court that she had lied, when she said that she could be fair, I think there was no option for the court. The court had to discharge her. It was clear that she had obfuscated and clear that she had lied to the court. The court was in a position where it could only make one decision.
Didn't the court say, as I read through the briefs, I recall reading a section where the judge he points to her reaction to his questions and how she responded in a way that gave him greater assurance that she didn't perceive the book as I'm not saying it's right. I'm just saying this is what he was saying, and part of his reasoning, that he found her to be credible when she responded with surprise at the questions that were being asked of her.
She may have expressed surprise, Your Honor, but clearly the answers she was giving turned out not to be credible. I mean, he could have believed her at that time, but how could he believe her when she gave a statement that was completely contradictory to what she had said earlier? She's a Harvard graduate. She's the author of the book. She's certainly the best person in the world to know whether the characters in that book were predatory or not. When she said originally they were not predatory, and then 5 days later said that were predatory, what other conclusion could one reach that she was lying, despite the fact that she may have been credible? So, despite the fact she may have been credible at an earlier time, she now was clearly displayed a lack of candor to the court, and the court was in a position where it had to discharge the defendant. Now, Your Honor, Judge
I think
Mazzarelli,
you should get to the Malino
yeah,
issue.
I know. I'm getting to-
Okay?
Yes.
You've taken a lot of time.
Yes, I know. Even if there were 12 qualified jurors on this panel, which there were not, the jury was overwhelmed by such prejudicial bad evidence. This was a trial of Harvey Weinstein's character. The people were making him out to be a bad person. This was a trial of his character. And the court, even if the prosecutor had successfully identified a proper basis for admission of prior acts, which it did not, the probative value was clearly outweighed by its prejudicial effect, especially when the prosecutor started out with, in this case, with having 3 unrelated sex acts as part of the indictment. It was built in Molyneux to begin with. They didn't need, the trial became a trial of 7 women, a dozen acts of prior misconduct.
When
that
you
spanned
talk
20
about the acts, the uncharged acts relating to the women against whom there were charges, why wouldn't those particular incidents be really sort of part of the race gesti, or part of something that would fill out the picture of what was going on here?
The people offered 2 reasons to introduce the Molyneux, and neither of which were justifiable. One was to show lack of consent. People versus Vargas clearly says that when the credibility, as in this case, when the credibility of a complainant is at issue, as to whether a sex act is consensual, evidence that the defendant engaged in sexual misconduct with others is not permitted, and only suggests that because of it, that the defendant did something before, that he did it again, which is exactly the reason we don't want this type of evidence coming into the case.
But I think my colleague was referring to the, because I separate the Molyneux issues into Molyneux rulings concerning the charged complainants and the Molyneux issues in uncharged complainants, right?
Yes.
Uncharged victims, right? So, and to me, those is 2 separate analysis. And I believe the question was with respect to the ones that were charged.
Right.
Why would that not have been,
Well,
that's certainly allowed.
of course, the crimes that were charged, obviously, but we're talking about
talking about the other
uncharged,
ones.
the uncharged
Okay.
crimes.
All right.
And I see my time is up. I'll say,
I'm gonna give you 2 more minutes because we talked over you.
okay, thank you. A second improper reason for trying to offer the Molyneux evidence was the district attorney said an intent to forcibly compel. Only Haley alleged force. And the defense theory was that Haley fabricated these claims of forcible compulsion. The issue was whether the forcible acts happened at all, not what the intent of Weinstein was. If the jury believed that the forcible acts happened, then Weinstein's intent would be inferred under Vargas again, which we're relying upon, from the commission of the acts, and any prior acts would be impermissible propensity evidence. Sandoval is unprecedented. Our research has not disclosed or found any case, certainly where someone has never been arrested or convicted. We've never found a case where a court would allow in 28 prior acts to be used to cross-examine a defendant.
You're not arguing that all of those rulings were improper, are you? On the Sandoval,
On
all
the acts?
28.
Well, there was no balancing at all. I think the prosecutor would say, well, they asked for 32 and we got 28. It's totally preposterous. No responsible jurist, in our opinion, would conclude that a jury could be capable of using this amount of evidence for non-propensity evidence. So the defendant is in a stranglehold. He's in a stranglehold on the direct case because of Molyneux. He's in a stranglehold on his own case because of Sandoval, and we've got a reversible error being committed in the voir dire. So he was in a legal vice in this case, and I'll save the rest for rebuttal, Your Honor.
Thank you. You may proceed.
May it please the court, Valerie Figueiredo for the people. This court should affirm defendant's conviction. Beginning with defendant's claim concerning juror number 11, there is no evidence in this record that juror number 11 lied about the subject matter of her book. In fact,
Well, she wasn't completely candid.
respectfully, Your Honor,
At the very least, you have to acknowledge that.
respectfully, I do not. She was entirely honest and candid. She admitted from the very beginning, from the very first January 17th inquiry, that there were teenage girls sleeping with older men. She then is asked on January 22nd whether the label predatory applied to those relationships, and she says that it could be considered predatory, but she herself did not personally consider it predatory because the girls were consenting members of those relationships. The fact that she may not have considered it predatory is irrelevant because she admitted to the facts underlying that conclusion. She told you from the very beginning that there were teenage girls sleeping with older men. In fact, her novel was not just about those sexual relationships. Her novel was a coming-of-age story set in the 1980s. It was fictional. She explained that there were other multiple storylines, such as the teenagers grappling with their parents, grappling with alcohol, grappling with drugs. This was not a book about sexual relationships or predatory older men, and she was candid about all of that. At the end of the day, the book bore no relationship to defendant. It did not concern the charged forcible conduct alleged in the case involving adult women, and it simply did not demonstrate that she had any type of bias or a state of mind that rendered her incapable of issuing a fair and impartial verdict.
Okay, why don't you deal with the Molyneux issue?
What is your rationale for introducing the testimony of the three uncharged victims, Young, Dunning, and Wolf?
The testimony of Young, Dunning, and Wolf, as Justice Burke found, was directly probative of defendant's state of mind. It indicated his knowledge that the women were not consenting to sexual acts simply because they had agreed to be alone with him, simply because they had come to him for professional assistance.
Why wasn't that accomplished with the three women who were complainants? I mean, that for me is the problem. You already have three women who give you three different types of stories of the horrors they allege they experienced with him. I think you've covered that. So to pile on with three uncharged complainants, three uncharged victims, is leaning really close to that propensity line.
Well, respectfully, Your Honor, all Molyneux evidence is propensity, but the court has recognized that it's admissible when it's relevant to a material issue of fact. And here it was relevant to defendant's intent. As Your Honor pointed out, intent was hotly contested below. The centerpiece of defendant's defense was that all these women wanted it. It was part of a quid pro quo. They were either in a romantic relationship with him, or they wanted it for they wanted the sex in exchange for professional assistance. The fact is that the testimony of Young, Dunning, and Wolf demonstrated that defendant would have understood that just because women were coming to him, were seeking his professional help, it did not mean that they were consenting to more. This is very different from Vargas, and that's the second reason.
I don't understand how that wasn't established through Mann.
Because
you had a 5-year relationship with him after the assault.
Because Mann's allegations were not so unambiguous that there would have been no doubt in a juror's mind that defendant intended the forcible element of the first-degree rape. Again, when Justice Burke...
You're saying that you wanted to prove what he did with Mann by introducing the testimony of those other three women?
No, certainly not. Mann's allegations would have established, if believed, would have established the elements of the offense. The Molyneux evidence, however, was directly probative and rebutted defendant's defense of consent and was probative of his state of mind. It showed that defendant would have understood that women were not consenting to sexual acts simply because they sought his professional assistance. Again, unlike in Vargas, where the victim's allegations were unambiguous use of force, it was a stranger situation where there was at most 2 meetings between the defendant and the victim. It was a brutal rape where she alleged that the defendant had found her in the elevator, had blindfolded her, had dragged her to the roof of the building where he raped her. In that context, the Court of Appeals says, yes, you can infer the defendant's intent because the allegations of force are unambiguous. Here, Mann doesn't testify that she ever told defendant no. She doesn't physically resist. She shuts down and says that she basically obeyed defendant. With very little force, he's able to rape her. And for that reason, because her allegations were not as unambiguous and as stark as in Vargas, a juror might have a doubt as to what was in defendant's mind, what his state of mind was. And Young, Dunning, and Wolf's testimony demonstrated that he would have known that these women were not consenting simply because they came to him for professional assistance.
Counsel,
Where the women were of the uncharged crimes were not the victims for which were being prosecuted, though. Where was the balancing that's supposed to go on in Molyneux? This was incredibly prejudicial testimony.
Well, no, respectfully, Your Honor, it wasn't prejudicial for two reasons. One,
Uh-oh.
the court gave extensive limiting instructions. 3 times the court explained to the
The
jury,
fact that there's instructions doesn't mean it's not prejudicial.
but here we know
I'm
it
being
wasn't.
charged with 3 rapes, and here come 3 other women who claim I did the same thing to them, but I'm not being charged with that. That's prejudicial.
Well, it's not
So the
prejudicial.
question is, does that prejudice, is that outweighed by some probative value that supersedes that?
Respectfully, Your Honor, it wasn't prejudicial here, and we know that, not only from the thorough limiting instructions, but from the fact that the jury acquitted defendant of the forcible rape of man. If they had been swayed by propensity evidence, if they had applied propensity rationale, we certainly would have gotten a conviction on the first-degree forcible
So then
rape of man.
why
We
did you
didn't.
bring him in then?
Everything about the jury's careful verdict demonstrates that they followed the court's limiting instruction, they parsed through the evidence, and reached a fair and appropriate verdict.
No, they didn't, because you don't.
counsel, your opposing counsel, opposing counsel referred to the Molyneux rulings in this case as unprecedented. What cases do you rely on under New York law that actually constitute precedent for the court's rulings in this case on the Molyneux issues?
He don't have
Well,
one.
parsing the Molyneux evidence, no one would quibble with
He
the
don't have it.
admissibility of the
He don't
uncharged
have it.
offenses as to man. Ample case law, which we
I'm talking about the other 3 women.
Right. As to Young, Dunning, and Wolf, again, I think Vargas is a perfect illustration of precisely why we were permitted to put forth the evidence here. It's well understood that Molyneux evidence can shed light on a defendant's state of mind and intent. And in Vargas, the court makes clear you can't put it in if the intent is easily inferable from the allegations. Here, we do not have the starkly contrasting scenarios
they don't
that
have
issued
it.
Vargas. We have one complainant, man, who doesn't even say she said no, and we have another complainant, Haley, who comes to defendant on the night of the charged offense, who was in an ongoing relationship with defendant, who defendant in his summation argues he would have understood himself to be in a relationship with her because of the fact that she kept coming back to him, because of the fact that she sent him these emails with saying nice things. All of that made his state of mind hotly contested, as the court pointed out, and for that reason, the testimony of Young, Dunning, and Wolf would have demonstrated not only how he orchestrated these meetings in order to get these women to engage in these sexual encounters, but also his knowledge that the women were not consenting.
I'm curious on some of the Sandoval rulings. For example, I believe that it was admitted that, or allowed, that the defendant threw a table full of food onto an employee in a meeting in the late 1980s, and that you sought to use that should he testify. Am I correct?
Justice Burke reached a fair compromise. He didn't allow in any general brutish behavior.
That's not general brutish behavior?
He let in evidence of defendant's assaultive conduct, and that evidence demonstrated his willingness to further his own interests at the expense of others.
What did leaving his employee on the side of the road in a foreign country have anything to do with this sex crime case? Other than, let's put in as much as we can to show that this guy is a terrible guy.
Well, 2 things, Your Honor. First, all of the acts that Justice Burke ruled would be appropriate for cross-examination directly pertain to defendant's credibility.
Get
and were probative of his veracity.
Hillary,
The
y'all.
fact that
Get
there were
Hillary.
No,
many
so you're really arguing that this was not overkill? I mean, there were certain items in the Sandoval that I thought, okay, that's fair game. If you, after being fired, ask an employee at the company to take computers and delete stuff, that's fair game. But some of this other stuff, let's inflame the jury's heart by telling them that he beat up his brother during a meeting. I don't see how there is a balance there on that.
Well, for two things. First, below, when Justice Burke issued his decision, defense counsel never complained that they didn't prohibit it. He didn't engage in any balancing. We know that the court issued a fair compromise because he ruled out any questioning regarding anything having to do remotely with sex and any, I see my time is up.
Well, he threatened to cut off someone's genitals.
I'm sorry.
He allowed in a threat to sever someone's genitals. That's got to do with sex.
But the threatening behavior, again, goes directly to demonstrating his ability to put his own self-interest at the expense of others, and that goes to the heart of honesty and integrity. The fact that there were many of these acts only indicated how defendant chose to live his life.
Yes, and counsel, you know what? There are trials every day where we have defendants who have a rap sheet a mile long. A mile long. They'll have 20 felony convictions on their rap sheet. And I've seen no judge say, go ahead, go to town on all of them, because they don't let you go into the facts. They usually just let one or two in. I mean, there is a balance.
And respectfully, Your Honor, Justice Burke engaged in that balance here. He did not allow any cross-examination regarding bullying behavior. He didn't allow any cross-examination.
But you know, when you talk about balance, and I understand what you're saying, there are certain things he didn't allow. On the other hand, suppose he would ask for 150 things. If he let in 100 things, would that still be balanced? And it's somewhat rhetorical, my question, which is balance isn't just that somebody excluded or that the judge excluded some stuff, but looking at what was let in relation to its impact on whether the jury could otherwise decide the case, not based on the fact that this is just a horrible person. That's really the balance, not what was let out.
That's correct, and perhaps if this involved a case that had 100 or 150 allegations, it would present a different scenario. But here, we do have the court having engaged in a fair compromise. He did let out a fair amount of behavior.
So 30 non-convicted, and they're not convictions, not one of them, acts. That's balanced.
Well, as you point out, the fact that they're not
Rob had
convictions, that
22.
they're just bad acts, if anything, makes them less prejudicial. But the fact that there were so many is only indicative of how defendant lived his life. The court was not required to unduly
You know,
sanitize
which
that.
proves the point. You're saying this is just him. He's a bad guy. He's a lot of acts because he's just bad. So, you know, to say it's indicative of how he lives his life, he doesn't get convicted because he's a bad guy. He gets convicted for these particular crimes. And that argument, I have to admit, it's kind of rubbing me the wrong way.
I don't disagree that he doesn't get convicted for his past conduct, but in fact here, all of the evidence that he did, that Justice Burke would have permitted cross-examination on, was directly probative of his veracity. It had to do with whether he had asked other employees to lie for him, whether he used his company budget to hide personal expenses, whether he used his friend's social security number to obtain a fraudulent passport. All of that are instances where defendant's credibility are all instances that are probative of his credibility and would have been permissible lines of questioning if he had chosen to take the stand.
Thank you. Counsel.
Your Honor used the phrase piling on. I don't think there's been a case that I can recall where piling on was as evident as it was in this case. The Court of Appeals has said clearly there has to be strict scrutiny in Molyneux evidence because it's so dangerous when it comes into the jury, and strict scrutiny as to Sandoval as well. And the prosecutor said that this juror, number 11, was an extremely honest juror. If I just can quote, and I'll within the time, does the book have anything to do with predatory older men? It's not a predatory situation at all. Does it have anything to do with the sort of individuals who young women who may be involved with older men that may be considered predatory? No. 5 days later, January 22nd, there are predatory men in the book. I don't know how much clearer it could be that this juror lacked candor and should have been discharged immediately, and it was reversible error, not subject to harmless error analysis. Weinstein sought no special treatment here, but he expected the trial court to protect his constitutional guarantees with the same vigor as any defendant, any of the defendants you mentioned that come before the court with prior records. That's all he asked for. He didn't get it. And considering the unprecedented trial publicity, the trial court had a heightened responsibility to ensure that Mr. Weinstein received a fair trial. And that possibility was destroyed by the Molyneux ruling, the Sandoval ruling, and the challenge for cause that was not granted. Thank you very much.
Thank you.
All right, y'all. All right, y'all. That was my little presentation. What do you guys think? Gucci, you want to come in and share your thoughts on this? You want to share your thoughts on the hearing? Hold on a second. Somebody's calling me. Hold on. Sorry about that. So Gucci, are you coming in or not? I'm gonna end this live and I'm going to see you guys later because I gotta go eat my lunch. Sorry, I'm gonna go eat my lunch. I gotta all right guys, I gotta go. I'll see you guys later. Somebody coming in or what? Gucci, are you coming in? All right, I'm gonna end this live. You guys have a good one. Nobody want to talk about this what we just watched, so I'm gonna end. I'll see you guys later. I have another meeting to go to later. Bye. Okay, hold on. Somebody just put some. All this the prosecutors do. So eager to convict that they said evidence we gonna pile as much as to prove an act. Yep. Yep. That's what they do, T girl. Yep. That's what they do. Okay. I'll see you guys later. I'm gonna take a nap. I got up early this morning. Oh, there go Gucci. Hold on.
At first, his attorney, when he first talked, he was rumbling a little bit, didn't say
I
much.
think he was
But
nervous.
yes, but when the prosecutor came up and that judge started eating her butt up, I guarantee you Harvey's gonna get his case reversed because the judge said one thing. Okay, you got 3 people that you charged for him rape. Why didn't you use those? Why are you bringing 3 people who wasn't charged? So
That's the
basically,
same thing with Robert. Same thing. You
yeah,
know, Robert had 6 people, 6, right? And then they
mm,
brought 22 more.
right. And what the judge said that make a lot of sense. Um, so basically, you bring these people in to try to show relevant conduct to the jury. Said, hey, he did this to these 2, so why didn't you charge them? Just like the judge said. So that and if you look up that circuit, that's why a lot of people in the federal system, when they get sentenced in a lot of places, they try get transferred to New York Circuit because New York Circuit and Cleveland Circuit is the 2 main circuit that the judges are very fair. A lot of people like if you know anybody in the federal system, you ask them,
That's
they would
not
tell you,
federal.
yeah,
The case is that's a
no,
state case.
that's a
That's a
state case. I
mhm.
know, but I'm just saying the New York State and federal circuit, they are some of the best. They got some judges that go by the law, and I
What's wrong
love.
with your headphones?
I don't know. Oh, it just fell out my head. Man, I'm trying to make breakfast.
Oh, what you cooking?
I'm not probably make me an omelet. I'm hungry.
Yeah, I think I'm gonna make me an omelet too.
I'm gonna make me.
What is wrong with your headphones? It's like take it off your chest.
Let me see. Can't it's still
Now you're breaking up. But that was good, but you're breaking up
okay?
now.
So anyway,
Yeah, much better.
I kind of like the judge this time with this, and I believe that's going to be a case that a lot of people going to end up using just this appeal for Harvey because I'm so tired of these people always want to use relevant conduct, relevant this, relevant that. But did you hear the judge make a point? The judge said, wait, the young lady, man, that's claimed Harvey did this to him. She ended up turning around being his girlfriend for 5 years after that. So how could she be that rape? So it's just a lot of stuff that you pay attention to and you're gonna be like, wow. So it's a good thing. You know, people should be tired of all these people coming back when they don't get what they want and claim you abuse them. They should be.
Hmm.
All right, I'm going
Hmm.
back in the bushes. I don't want to burn my
Okay.
eggs.
Thank you for coming. All right, guys. I'm going to let you guys go. I go just yawning again. Sorry. There I go with this yawning again. So, guys, keep Robert in your prayer. Prayer works. Prayer works. You see all these cases that's coming about. We got so many precedent cases that's gonna help overturn Robert's conviction. Hallelujah. And I'll see you guys later. See you guys later. Bye.